Hi, my name is Megan Troick. Thank you for joining me on this video. This is a series of probate videos that we're doing here at the Law Office of Brian Fagan, and it's such a pleasure that you're on here today. One of the things that we're going to discuss today, we're going to look at the 8 steps to Texas Probate. I know it can be a dry subject, but I'm going to try my best to make it at least a little bit more lively. So when you come to an attorney, a probate attorney, with a will, the first thing, or without a will, the first thing we have to do is the filing. This is the application to enter the will or to probate the estate of the person in the Texas court. You have to file in the county where the decedent, the person that passed away, resided. You file that application. After you've filed it with the court, there will be approximately 2 weeks, a 2 weeks waiting period before you'll usually hear anything about the application. During this time, the county clerk will post a notice at the courthouse notifying the public, notifying any creditors out there that an application has been open. This is the required notice of the administration of the estate. Therefore, anyone who may have a claim now has to come file a claim with the probate court in this court proceeding. If they fail to see it, their claim may be one of those that will not get paid under this estate. So once you have filed the application, the posting period has passed, then the will has to be taken to the court for validation. So the actual will with the actual ink stain has to be taken to the clerk, who will take the will, look at it, make sure it's the original, and what they're really looking for is whether this is a legal will. For many people, the original will is lost and all they have is a copy. And in that situation, different things will have to have happen, different affidavits, different witnesses, in order to prove that will up so that it will be a valid, accepted will by the court. The person will verify the names of the executor, the name of the decedent, to make sure that this is actually their will. So after the will has been accepted into probate, the executor or the administrator, depending on if there's a will or not, that's named for the estate, will go out and start cataloging or inventorying the assets of that person. They will take into effect everything that that person has, put a value of it on it. They usually have about 90 days in order to turn this inventory and appraisement into the court. Many times they do not even have to get an appraiser. They can use their self-appraisal by court order so that the estate doesn't have to spend that money in order to get an actual appraisal. Usually you have actual appraisal in really extensive and really complex estate. How detailed the inventory and appraisal is directly reflected by the complexities of this estate. Whether there is likely to be a question of whether the asset is owned by beneficiary creditors, and all those things will come in, and other variabilities that may affect how intricate an inventory appraisal will be. But it's directly correlated to how complex the estate is. So in the inventory appraisal, if they're married, the entire asset gets listed. However, you will show what portion belongs to the estate and which portion belongs to the spouse that's alive. The purpose of the inventory and estate is to make it clear what any creditor can attach to and what the creditor cannot attach to, because you cannot give away in a will what is not yours. So if you have a community estate, you cannot give away the entire estate. Half of that estate minimum belongs to your spouse that's alive. Okay? The next step is to identify the beneficiaries. If the decedent had a valid will, the executor will notify the beneficiaries of the estate. If nothing was filed, if there's no probate, if there's no will that needs to be probated, then those heirs that are listed in the determination of heirship will need to be notified. This can be a challenging predicament for any legal representative if you do not have a clear access to the heirs, if there's no will out there that lists the children, if there's no one alive to list the probable heirs, then you have a situation where you may even have to appoint an attorney ad litem. All heirs must sign the application or must be personally served with an application. If there are potential unknown heirs or deceased heirs or people who may have deceased after that person's estate that you're probating, the complexities of that probate hearing becomes exponentially difficult. However, you may have a situation where, though, you have incorrect or incomplete information. However, all applicants must prove the truth of the details in their application. They have to do it in writing as well as in their testimony. Now, many people can file an affidavit of their testimony and just prove up a more limited situation in court. However, the applicant has to prove the truth of the actual facts by oral and by written statements. The next thing you have to do is to notify the creditors. Decedents usually leave behind debts. They may have left behind credit card bills, a mortgage. These must be resolved out of their estate. Their portion of the debt must be resolved out of the estate. Typical debts include bills, mortgages, as I said, household expenses. Creditors need to be notified, usually by that executor or executrix, and given the opportunity to file a claim against the estate. This notice to the creditors can be legally accomplished through a notice by publication in the news, in a local newspaper. So usually you have a notice by publication and a notice by citation, one at the courthouse, one in the newspaper. Then the next step, step 7, is to resolve the disputes. The estate cannot be finalized if family members and other potential beneficiaries are fighting, or if they are challenging the will, or if they have any claims against the estate that they're filing. Yes, beneficiaries sometimes have claims against the estate, and while they're taking under the estate, they're also suing the estate. These disputes can be heard in the same probate court. Probating a will is often emotional. A lot of the times people will fight over the simplest things, because not only are they probating the will, they're walking alongside with all the hurt that may have come up, one, from the death of their loved ones, and the death of the opportunity loss of that loved one passing. And the person contesting a will is now in a situation where they may have to prove, if they're challenging the will's validity, that the will, there's something wrong with the will. It may be that they're disputing the executor, because the executor might be a drunk, or you name it. Many people contesting a will never get to court, because many times it's settled in mediation, and this is what maintain the family unity and may be the best thing in a situation like that. Sometimes the dispute never even get to a mediator, because fortunately families resolve these issues. And step 8, finally distributing the assets. All the debts are paid, everyone is happy, they're fine with the executor, the inventory is filed, bills are paid, the executor distributes the estate according to the will or according to Texas intestacy law. That's a summary of Texas probate proceedings. Thank you for joining me. Thank you for allowing me to present this to you today. My name is Megan Truick with the Law Office of Brian Fagan. Thank you.